Hello, I'm Yvonne Lau from the HHS Office for Human Research Protections. I'm going to talk to you about regulatory options for secondary research with private information and biospecimens under the revised rule that was published on January 19th, 2017. Here is an overview of this talk. I'm going to give you the concepts of secondary research and identifiability to start with. And then I'm going to talk about doing secondary research with non-identifiable materials. And then I will go on to talk about secondary research with identifiable materials. And this can be done as exempt research or as non-exempt research. So I'll go through these concepts as I go through this talk. First, the concepts of secondary research and identifiability. What is secondary research? This is the research use of information or biospecimens originally collected for non-research purposes. For example, blood that is left over from routine clinical tests, general information that we collect for other purposes, like when we register to take a course at the university, or for other general purposes like collected for census purpose and so on. So the key here is that these information that are originally collected for non-research purposes. Or they could be information about specimens originally collected for research studies other than the proposed one. So researchers obtain blood samples left over from a study evaluating new diabetes drug to conduct a new study on genetic predisposition of diabetic patients to Alzheimer's disease. This could be an example. In other words, the key here is this material can come from research, but it was not collected specifically for this current research. So what is not secondary research? We've just talked about what is secondary research. Here we're going to talk about what is not secondary research. It is not secondary research when investigators interact or intervene with living individuals to obtain their data or biospecimens specifically for the proposed research, for the current research. Under this kind of situation, we would refer to this type of studies as primary research. In other words, the data and biospecimens are collected specifically for the purpose of the proposed current research. Now we're going to move on to talk about the concept of identifiability. To start with, I just want to say that there is really no change in the current revised common rule, in this current version of the revised common rule, to the definition of identifiability. It remains information for which the identity of the subject is or may readily be ascertained by the investigator or associated with the information or the biospecimens. What is different or provided in the revised common rule is the definition, the specified definitions for identifiable biospecimen and identifiable private information. And this is purely for clarity purpose. There is also a commitment in the revised common rule that federal agencies will collaborate at least every 4 years to re-examine the meaning of identifiability. And we understand that, because of the changing landscape of today's research, things change very rapidly. What is currently considered as not identifiable, it's really a very fluid concept. And so we take into consideration that the fluidity of this concept, and we build into the rule that federal agencies will re-examine this definition every so often in order to be able to support the changing environment. There is also a commitment to examine and identify analytic techniques and technologies that are capable of generating identifiable private information or biospecimens. And the first technology that will be looked at is the whole genome sequencing. So now we are done with the concepts, explaining the concepts. I'd like to go on to talk about secondary research with non-identifiable information and biospecimens. So secondary research use of non-identifiable private information or non-identifiable specimens Essentially, if we remember, it does not involve interacting or intervening with living individuals to collect their materials specifically for the proposed research. And in this case, we also indicate that it's non-identifiable materials. So in other words, in summary, it does not involve human subjects. And for that reason, it does not require IRB review and approval under the regulations. This is exactly the same as how we've been doing things under the pre-2018 rule. So there's no change under the revised common rule. One type of this kind of research, researchers often refer to them as coded, research with coded biospecimens or coded private information. I want to make sure that you understand that just referring to something as coded does not necessarily make it not human subjects research. For research involving coded biospecimens or coded private information to be not human subjects research, this has to meet the following two criteria as well. First, it's not collected specifically for the research in question, and we've talked about this over and over again. This, when it's not collected specifically for the research in question, it is not human subjects. There's no intervening. And, all right, investigators cannot readily ascertain the identity of the individuals to whom the data specimens pertain. So they're coded, but they're coded in such a way that there's a real firewall that the researchers they do not actually keep keys to the codes, and they cannot really go back and link this materials back to living individuals. So those are key. And if this research with coded biospecimens or coded private information meet these two criteria as well, then it is not human subjects research. And again, as I've already said, there's no change on the revised common rule. This is how we interpret and understand this even in the pre-2018 rule. We're going to move on to talk about secondary research with identifiable information and biospecimens. And precisely because they're identifiable, then this makes this secondary research human subjects research. What are the regulatory options available for secondary research with identifiable private information or identifiable biospecimens? Here they are. Again, first, we want to see if any of the exemptions that are available for this kind of research, their conditions can be met, and so we can use these exemptions. And the exemptions that we could use are 4, 7, or 8. 4 is what is currently is expanded on the pre-2018 rules, and exemptions 7 and 8 are new exemptions. Or if we find that these exemptions actually do not apply, then it will have to be conducted as non-exempt human subjects research. And these are the options that are available for non-exempt human subjects research. So you could get standard informed consent. You could ask the IRB for a waiver of informed consent if applicable. Or one could consider this new option called broad consent under the revised common rule. I'll be talking about these in more detail. First, exemption 4. Secondary research use of identifiable private information or identifiable biospecimens under exemption 4. In the new revised common rule, the materials that we use, in other words, the private information and biospecimens, they no longer have to be all existing prior to the start of the research. Now, this is a new aspect to this exemption, compared to what we know of in the pre-2018 rule. Under the pre-2018 rule, all the materials have to be already in existence at the time when the investigator began the research. Under the revised common rule, this requirement is removed. So the materials do not all need to be already in existence prior to the start of the research. So the good thing would be you could, have a researcher who's interested in doing pancreatic cancer research and have been getting material specimens from a hospital that specializes in treating patients with pancreatic cancers. So as a routine from clinical management of these patients, there would be specimens from biopsies or from surgery. The leftover are being provided to this current investigator who wants to study them under a secondary research condition. In the past, all the specimens will have to be already in existence prior to the researcher starting the research. But under the revised common rule, because the hospital continues to have these clinical specimens being available since they're specialized in this particular type of cancer, and the researcher, if they so wish, they could continue to receive this material for the purpose of their research, and they could potentially still apply the exemption 4 under the revised rule. So exemption 4 under the revised rule, it is exempt if the identifiable materials are publicly available. And this is exactly what is in the pre-2018 rule. So a situation, an example of this would be, identifiable sources that a researcher can obtain from a public library, or, at a small cost, they could get it from some commercial providers, as long as, the general public, by paying this small cost, they can also get hold of this material. So that's the kind of things that we're thinking of. So it could also be exempt under this second provision, which is information which may include information about biospecimens, is recorded by the investigator in such a manner that the identity of the human subjects cannot be readily ascertained directly or through identifiers linked to the subjects. Up until this point, it's pretty much the same as what is written in the pre-2018 rule. Right? So investigators, initially they might see identifiers for the information or the biospecimen. So for example, when an investigator go into a set of medical records, right? The investigator being the physician, they can look at the medical records, they can see the identifiers. But as they will download information, just relevant information without identifiers to form their data set so that they can do the research on. All right, this is the kind of situation we're talking about. Now, so provision 2 is essentially the same as the pre-2018 rule. What we have added is the last bit in bold. This wording that says, and the investigator does not contact the subjects or re-identify subjects. It's added there just to, make it especially clear that while the investigators might have access to the identifiers at the beginning of or before they start the research, as they collect their data set or collect their set of biospecimens, once they have done that, they're removing all the identifiers so that they can actually not go back and re-identify. So this is the situation with this particular provision. So with exemption 4, it has actually been expanded under the revised common rule, and there are 2 additional provisions under exemption 4 that investigators can potentially use. Here, the provision 3 says investigators' use is regulated under HIPAA as healthcare operations, research, or public health. So in other words, if the investigator who is going to be doing the secondary research, and they belong to a HIPAA regulated entity, right? They can actually continue to use the information with identifiers for their research. So they can retain the identifiers. Note that HIPAA does not apply to biospecimens. So we're really talking about information. All right. And last but not least, the last provision, the 4th provision, is research is conducted by or on behalf of a federal agency using data collected or generated by the government for non-research purposes, and the information is protected by federal privacy standards. So anybody who is kind of like doing work for the government or on behalf of the government and using data that the government has collected, and all this data is actually it's protected by strict federal privacy standards. So exemption 4 could apply in those situations. Now we're going to move on to 2 completely new exemptions under the revised rule that we could use or we could consider to use with secondary research. Exemption 7 refers to storage or maintenance of identifiable private information or identifiable biospecimens for secondary research. It's a storage or maintenance. And Exemption 8 is the use of this material, secondary research use of this identifiable private information or identifiable biospecimens. I just want to add here that for Exemption 8, there is also this requirement: the investigator does not include returning individual research results to subjects as part of the study plan, except when required by law. Now, both these exemptions also have additional requirements that need to be met in order for them to be able to, in order for investigators to be able to apply them. So both these exemptions require the use of something called broad consent under the Revised Common Rule. This is a specific term under the Revised Common Rule, and I'll talk about this a little bit towards the end. The other thing that is required is something called limited IRB review, and the review is for privacy and confidentiality protection and some aspects of broad consent. It's called limited because the review is only limited to confirming that the conditions for the exemptions are met. It is not this usual standard IRB review that we know of and that we're familiar with. In other words, we don't have to have the IRB review the 46.111 criteria. All the IRB is required to review is to make sure that, to verify that the conditions for the exemptions, 7 and 8 in this case, are met for them to be, for the investigators to be able to use this. Now, for limited IRB review, this can be done using the expedited review mechanism, which means by a designated experienced IRB member. And there's no expectation for annual continuing review at all. Of course, if the investigators throughout the course of the study decide to make some changes, then the investigators might need to go back to the IRB to make sure that whatever change that they've made will continue to meet the criteria required for the exemptions for them to be applied. And so you may have this another episode of a limited IRB review, or for that matter, an IRB review if the exemptions don't apply. So I'm going to show you this flow chart here at this moment just to give you a reminder of how we think about these things. So we start off by saying that, okay, well, we're dealing with researchers who are doing research, and there's a question of whether it is human subjects research, right? And is there any interaction or intervention with living individuals for the purpose of the current research? Or are the investigators keeping identifiable private information, identifiable biospecimens? If the answer to this question is no, right, in other words, it's secondary research with non-identifiable materials, then there's no IRB review needed, right? Institutions might still have policies for investigators to go through them to make that determination, but it's not the kind of IRB review that we talk about. On the other hand, if the question to this is, if the answer to this question is yes, right, there is, in the case of secondary research, there are use of identifiable, investigators have access to identifiable materials, right, then we have to go to the next question, which is, can it be an exempt situation? Can it be an exempt research situation? And if the answer to that is yes, right, we want to ask the question, so we're talking about exemptions 4, 7, and 8, right, essentially. But if the exemptions involve 7, if the exemptions do not involve 7 and 8, so in other words 4 in this case, right, no, then again there's no IRB review required. On the other hand, if the exemptions actually involve one of these 7 or 8, don't forget that we actually do need to have a limited IRB review situation to make sure that the conditions are satisfied before the investigator can use these exemptions 7 or 8. Now, what if these exemptions don't apply, right? So no to the question of is it exempt. Then we go to the standard non-exempt human subjects research that requires IRB review. And this is where we're going now to follow. So non-exempt secondary research with identifiable materials requires informed consent or waiver, right? They're non-exempt research. They require the requirements of the rule, which is the IRB review, and it requires usually informed consent unless the IRB has waived it. So the options for informed consent: standard informed consent that we know of, or the elements of informed consent in 116, A, B, and possibly C need to be met. Or there could be the situation of, requesting a waiver of informed consent from the IRB, and conditions need to be met for the IRB to be able to do this. And last but not least, this new option that is now available in the revised common rule called broad consent. I'll not be going through standard informed consent, but I'll go straight and talk to you a little bit more about the waiver of informed consent and then later broad consent. So here you are, the conditions for waiver or alteration of informed consent for secondary research with identifiable materials. The 4 provisions here are what we're all used to, because they are in the exact wording under the pre-2018 rule. So no more than minimal risk to the subjects. Research could not practically be carried out without the waiver. And usually we refer to something being not practicable. It's when the scientific validity might suffer significantly. That's a kind of situation. So it's not a case of inconvenience. The research will not adversely affect the rights and welfare of subjects, even if the consent was waived or altered. And whenever appropriate, the subjects will be briefed. So these are the 4 standard conditions that we're so familiar with. Under the revised common rule, there is a new requirement that needs to be met. The IRB must determine that the research could not practicably be carried out without identifiers. And this word practicably was pulled out from the HIPAA rule, which refers to that the identifiers are necessary for the research to take place. So last but not least, I'm going to say a few words about broad consent, which is an entirely new concept under the revised common rule. So broad consent is permissible option only for secondary research. That is, again, a reminder, research using identifiable private information or identifiable biospecimens collected for either research studies other than the proposed research or for non-research purposes like, for example, from clinical routine collection. The use of broad consent, the idea is to facilitate storage, maintenance, and future secondary research with identifiable materials when the details of such future research may not be available as yet. So it's, it allows for this broad coverage, broad secondary future research. It's primarily used to qualify for exemption 7 or 8, but we don't have to use broad consent with these exemptions. It can stand alone. It may be used for just non-exempt studies in order, for example, to show more respect to people's autonomy and decision for use of their identifiable materials. Now, I have to emphasize that broad consent is available as an option out of the numerous options that we have talked about. So nobody is required to use broad consent under the revised common rule, so to speak. And this brings us to the end of my talk. Please refer to the text of the revised common rule available on OHRP's website for a complete and accurate description of the regulatory requirements. And for this presentation, please review the regulations at sections 46.102E, 46.104D, that's about all the exemptions, and 46.116, which is about informed consent and broad consent and so forth. So if you have questions about the revisions, please submit your questions by email to ohrp@hhs.gov. And don't forget to check out the OHRP website at www.hhs.gov/OHRP for resources on the revised common rule. Thank you for your attention. We invite you to review other webinars on the revised common rule that OHRP has created to inform the research community. And I also want to mention here that this is part 1 of a 2-part series. There is a part 2 to this, so if you're interested, don't forget to review part 2 as well. Thank you very much.